Session. So we're dealing with the detailed scrutiny of the Digital Safety Commissioner Bill 2017, private members motion bill, sponsored by Donegal Lira. So I wish to draw your attention to the fact that by virtue of section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the chairman to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. If you are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that where possible you should not criticise or make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. I also wish to advise you that any submission or opening statements you have made to the committee will be published on the committee website after this meeting. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make him or her identifiable. I just remind members and witnesses to turn off your mobile phones or to switch them onto flight mode as they interfere with our sound system. I'd like to first of all welcome Minister Richard Bruton, who is accompanied today by Trina Quill, Principal Officer, Broadcasting Policy Division, and Dúlto O'Brien, the Assistant Principal in the Broadcasting Policy Division. We're also here with Deputy Donegal Lira, who has sponsored this bill. And before I ask Donegal Lira to give us an overview, I just want to take this opportunity to congratulate the Minister on your new appointment, and we look forward to working with you and your department. Deputy O'Leary, do you want to give us an overview of the bill?
Thanks very much. I'm supposed to thank the Chair, and I suppose I'd add my congratulations to the Minister. I'm very pleased to have the opportunity to present this bill before you this afternoon. I know it's been discussed in previous meetings of this committee, and I commend the Chair, and I suppose I'm encouraged by the sentiments expressed by the committee on the need for a Digital Safety Commissioner of this kind. There's no doubt but that online safety has become one of the most significant challenges facing Irish life, and is arguably one of the most significant child protection issues of our times. It's one legislators very urgently need to face. While it is the case that this requires a policy response, an education response, it's also my belief that we need strong regulation and a statutory office with real powers and teeth as well. In most areas of policy, we generally accept that self-regulation is no regulation, and I do not see how this area is any different. It's for that reason that I have moved this bill, which I think would be a significant move towards moving a positive and safe online culture for all. This should be a permanent statutory body rather than office internal to the department. I take this opportunity to acknowledge the work of the Law Reform Commission, who produced the report on digital safety and harmful communications, from which this bill is built upon, particularly its primary author, Fiona O'Regan. We face significant challenges, and many, particularly parents, are concerned about what is happening online, and it's hard to blame them when we read the stories of predatory behaviour, harmful material and online bullying. While bullying in any circumstances is bad, the idea that it can follow the child home bothers many children and must be an extremely difficult experience for the children affected. However, this is not intended as an office solely responsible for preventing harm to children online, but the population as a whole, and should be responsible for the promotion of a positive online experience. I said at second stage that the internet is a significant public space that is part of the life of most citizens and increasingly the lives of younger citizens. As well as the risk it contains, it creates great value, which must also be reflected in discussions on the risks and harms associated with it. Our philosophy should not be to be hostile to the internet or to see it simply as a source of danger. We must try as best as we can that Irish citizens can be protected from those who use the internet for harm and abuse, but can also access the benefits of the internet. So we need a measured, proportionate and sensible response to the risks and hazards. This bill and a Digital Safety Officer, Digital Safety Commissioner is part of that. Technology and online platforms evolve very rapidly and dramatically, so it's vitally important that the remit of the office is drawn in such a way as to ensure that it stays abreast of all changes and is in a position to evolve. The primary proposed function of the Commissioner as outlined in the bill are, among others, to promote digital safety for all, to support and encourage the implementation of measures to improve digital safety, including oversight and regulation, and crucially, a timely and efficient procedure for removal of harmful communications. This would ensure that takedown procedures and removal of material are made available to all affected individuals by digital service providers free of charge. They will ensure that there is a code of practice of safe and responsible internet usage, develop national digital safety standards and ensure compliance with them. And they would have powers to revoke a certificate of compliance with the same as in Section 6. Crucially, the Commissioner would be responsible for ensuring digital service providers, such as websites and social media platforms, abide by those codes of practice and national minimum digital safety standards. There should be recourse directly to this office, but we should seek to have quick, effective and timely remedies put in place by the platforms themselves, without having to be forced to by the Commissioner in order to reach the standards. Because if there is a significant delay in dealing with harmful material, then some damage is already done before it is eventually removed. Some providers currently have good mechanisms, but some do not. We need legislation to ensure that where they are not stepping up to the mark and putting in place the safeguards, that they should be made to do so. I wish to address some of the criticisms which have been made of the bill, which I take in the cooperative spirit in which they were intended. These were stated at second stage speech by Minister Naughton, since replaced by Minister Bruton, who I will be anxious to engage upon with this. I hope that he, like his predecessor, does believe that there is a value for a body of this kind for a robust digital safety commissioner. I would note that I am very open-minded about all these issues and proposals and any issues that people might flag up, and I am amenable to any potential suggestions or amendments. To address the Minister's points, the first relates to a definition of harmful communications, a term used in this bill to denote when a takedown mechanism could be engaged. The Minister stated that the bill does not define what is meant by harmful communications, other than those which will be addressed through criminal law. It is possible that it would be appropriate for this to fall within the ambit of the Digital Safety Commissioner's office to draw this up, though certainly not, I believe, to be left to the provider. That they would define, that the safety officer, the Commissioner, could define what harmful communications would be suitable for takedown mechanisms. But on balance, I do believe that it would be appropriate, given that there is a legal requirement to be in compliance with Section 4 and 5, that for the sake of legal certainty, that it would be appropriate to define a definition. I am currently developing a draft of a definition, as I believe it will be necessary. Generally speaking, I think we need to look to the Law Reform Commission recommendations. This did not define specifically harmful communications in terms of a specific standalone offence or conduct, but it provided it as a description of a category of offences already existing, including Section 10 of the Non-Fatal Offences Against the Person Act, which would require updating in terms of communication, as well as what the Law Reform Commission proposes potential new offences. That's outlined in pages 5 to 7 and 167 to 172 of that report. These are behaviours which require legislation to make them clear and specific criminal offences, or to update existing legislation. While I am not proposing to introduce as amendments, at this point in time at least, to make them criminal offences in this bill, I do favour that these are the types of behaviours which we would seek to address. In general, this would include distribution or publication of an intimate image of another person taken without consent, threatening to do so, the taking of distribution or publication of an intimate image of another without consent, distribution or publication of intimate material where this seriously interferes with privacy or causes alarm, distress or harm to the other person, the distribution or publication of a threatening, false, indecent or obscene message to or about another person in circumstances where this is done for the purposes of causing alarm, harm or distress to another person, or is done persistently communicating with a person in circumstances which seriously interferes with the person's privacy or causes alarm, distress or harm, or any inchoate behaviours related to the same. As I say, this formula is something that I am working on and will communicate with the committee, with the Minister on that, but I do believe there needs to be a definition. The Minister further says that the bill provides for a role for the courts where an entity is established outside the state in respect of a harmful communication. It's not clear how this would work in practice. He did not elaborate on this, so I cannot necessarily describe what specific difficulties would arrive. I won't read all of this out. People have it in the opening statement, I believe. I can elaborate on it in response to questions, but I note that the extraterritorial elements of the bill are not particularly radical, or I believe particularly unusual, and I believe that the Law Reform Commission recommendations dealt with it quite comprehensively. I believe what's drafted is consistent with and entirely in keeping with existing practice on extraterritorial proceedings on Norwich Pharmacal orders in the rules of the Superior Courts. However, I will listen to argumentation and points in this respect, and in the interests of absolute clarity, I am willing to consider whether it may be appropriate to include a specific enabling provision in this bill. The Minister at the time also said that the bill imposes a number of obligations on digital service undertakings established in KIS. But obviously that is quite clearly the intention. It's not intended to be a dead letter, a soft body. It's intended to have teeth and powers. So I don't see any difficulty with that. Fourth, the overlap with other state organisations with statutory and non-statutory rules was stated not to be clear. Personally, I believe this is a matter that will require direction from the Minister. A lot of this is not something that can be dealt with in legislation, given that many of the bodies that are dealing with this are not doing so on the basis of legislation or statute, but on the basis of responsibility assigned by individual departments and government offices. So it's possible that some of this could enter the ambit of legislation, but to be honest, I believe that ultimately the Minister, if he wishes to support a bill and a proposal such as this, which I hope that he does, there will be a role for the Department in identifying work done by their offices, such as, for example, the Office of Internet Safety, which would be required to the Digital Safety Commissioner. I also note that this was briefly addressed by Ms Niamh Sweeney and Ms Niamh Comiskey of Facebook at the Joint Oireachtas Committee several weeks ago. I note they were not opposed to the idea at all, stating that we see great benefit in a single office having the ability to oversee and coordinate efforts to promote digital safety. Ms Sweeney went on to say that it would not be the intention of this bill to impact on free speech. The Commissioner's ability to issue a decision ordering the removal of harmful communications should be considered in light of the potential of limiting freedom of speech. It is important, therefore, to have a clear definition of what constitutes a harmful communication included in the legislation. I accept the point in relation to freedom of speech. We must be conscious of it in all our deliberations. The other point relates to the harmful communications definition, which I've already addressed earlier. Finally, just some of the points that have been raised with me separately. There's been a suggestion that it might be more appropriate that the parent minister or the key minister identified in the bill would be the Minister for Communications or Justice. Given the government have directed this bill here, that's clearly the view of the government. I would say it's probably the view of this committee as well. So I'm happy to take that on board and agree that the parent department should be the Department of Communications. In addition, just in relation to sections 3F and E, that does, I believe, require some amendments. Firstly, I believe that the onus that's placed on the Ombudsman for Children should perhaps be revised. Certainly there is a role for them, but I think that the key responsibility for directing any of this and initiating any of this in terms of material or curriculum should be from the Digital Safety Commissioner in consultation with the Ombudsman and the Department of Education and perhaps the NCCA and other relevant bodies. And also, rather than just simply producing material and documentation and so on, I think that it should be focused on working with, as I say, the NCCA to hardwire digital literacy into schools. And I know the Minister has indeed done good work in the Department of Education in relation to digital literacy already. So in a general sense, I believe these are constructive, positive suggestions. I'm anxious to hear the view of committee members. I will be very open to potential amendments across a wide range of areas. I want to see this bill improve, I want to see it progress, and I want to see a Digital Safety Commissioner established in this jurisdiction. I've also passed on my contact details in the opening statement to all committee members and indeed the department, so I'm open to people for any contact following on from this meeting.
Thank you very much, Deputy Leader, and thank you for your comments there, and we look forward to engaging with you as well over the next few weeks and months ahead on this, what is a very important bill. Minister Richard Bruton, I might ask you to make a statement.
Thanks very much, Hildegarde, and thanks, Donnacha O'Leary, Deputy Leader, for this bill. It's something that, as you know, as part of the government's digital strategy, we are anxious to work with the committee in this area. I mean, I have some little bit of experience in this area from the work I have been doing in education. Like we have, for example, we've required all schools to consult with parents regarding the use of smartphones in schools. Some 87% of primary schools have policies of absolute disallowance. Others have some forms of restrictions. So there is differing practices, but as you probably know, some schools have developed codes that cover not just in school, but parents' attitude to the ownership and use of smartphones as well among their children. So they have, I think that consultation will give us some idea of the direction parents and the school communities want to go in this area. The other thing, as Deputy O'Leary referred to, we have been very active in the area of developing materials through WebWise, which is part of our what they call continuous professional development section of the department. That is developing materials that can be used in the classroom, often with students as well as teachers, in other words, using students as ambassadors for improving people's resilience to deal with some of the experience they have on with social media, and I think their work is particularly innovative. It is supported, as you know, by the European community. I also, one of the major initiatives of this was to set up the government's plan has been to set up an interdepartmental group, which is being chaired by the Department of Education, and I attended their first meeting to emphasise the importance of working across the silos and developing a coherent response. The action plan, as you probably know, has a range of goals around online safety for all groups, better support, stronger criminal protections, better arenas for influencing policy, and in that context it's set up an advisory council which involves people right across the sector, helping to guide government in the development of strategy. So it has a lot of really valuable initiatives which I'm sure the committee is aware of, like having a single access point, equipping teachers and curriculum and so on around the school, developing supports in the arena of mental health, the new criminal offences, which as you know, isn't part of this bill, but is being developed. Indeed, I think it's part of the Labour Party bill as well. So there is a very strong momentum now for implementing change in the digital safety arena. So I suppose coming to this bill, I think I absolutely agree with Deputy O'Leary that it's time to move beyond self-regulation in this area. But of course we have to make sure that whatever we do is robust and that it is workable. My understanding of this area in European Union's context, there are different levels of regulation. They haven't yet addressed takedown, but where they have addressed regulation, they have different dimensions of regulation. In the audiovisual area, for example, they're envisaging regulation that would involve the oversight of a code of practice, but not taking in third-party complaints. So clearly, the idea of having third-party complaints is probably integral to what you're proposing, and I can see the sense of that. But the other models would have seen the codes, as you say, which some of them are good, some of them are bad, that they would be overseen, and that would be, in other words, you'd be someone riding shotgun on the companies in terms of their implementation of their codes. Whereas this model goes a step beyond that and says where there is disputes that are unresolved, they would be arbitrated upon. So I suppose that is the context in which it's probably important to have your definitions right if you're going to go into that, go from general oversight of codes to having third-party arbitration on what it is that you are going to have arbitration upon. I think that probably needs to be spelt out. I note that you're working on this. Now you did, as I understand it, what you spelt out there were largely criminal offences, where you seem to be envisaging that the takedown power would be in relation to things that were already unlawful. Now, there is an issue that probably needs to be teased through, and I will be asking the Attorney-General to help us tease through this. If you introduce powers for a body, a data digital safety commissioner to require takedown in areas where it's illegal, you do have the issue that the Gardaí also will be looking at illegal activities and working to ensure they're taken down. So one of the things that we will need to look at is in that category, what's the relationship with the Gardaí and the investigation that they might be doing. I understand the companies would have strict liability if they leave up something that's illegal that would expose them to liability, whereas if you move beyond the illegal ones to another category, which I understand has been done in Australia, where they've defined other areas such as cyberbullying, which would be short of something that's illegal but nonetheless undesirable and should be taken down, that I suppose we do need to decide what is the realm within which we're working. And I think that's one of the issues that I'm very happy to get advice from our own legal people as to how you would define that range, if you like, and also to make sure that if we are envisaging, as you are, takedown rights in relation to things that are illegal already, just to make sure that what we would be doing, or the Digital Safety Commission would be doing, wouldn't interfere with the Garda investigation and prosecution and so on. So just to, I'm not saying this is an insuperable, it's just one that there is an issue, I think, to be addressed there. So, those issues, I'd say, while I recognise the work you're doing, I think that there clearly needs to be some more work. Like yourself, I'm not an expert on what extraterritorial effects might be, and I recognise that you're saying that you would work with whatever advice we get from the Attorney General. I think our officials will be coming back to the committee later, and hopefully we will have a bit more advice from you at that point. So that's, I suppose, in some ways, that's the most core function of your bill. It refers to, most of these functions around C, D, E, and so on. So I think we just need to do a bit of work on that. But I think moving away from self-regulation is absolutely right, and let's define the scope of it, and let's decide on how the third-party complaint is defined and proceeded with. And the wider sections of your bill. I just need I think we need to think a bit more clearly about what it is we're trying to achieve here. Like, the government have established an interdepartmental committee where each person represented on that committee has the functions and powers to execute change. And we strongly believe that in all of these areas we need to ensure there's work across the silos, and we're creating that momentum to work across the silos, and we're also creating an outside advisory body to make input in and critique, if you like, what's being done within government. I would ask you to consider what added value would occur in someone who had a coordination role on top of that structure. Like, that structure, as that's now there, will report back to a cabinet committee, and we'll have ministers judging, is this being proceeded quickly enough? Are we doing the right things? Do we need to add new things to the action plan? Now, like, that is a tried and established, if you like, tier of power, authority and execution. Where a digital coordinator would fit into that, I think is open to question. Like, take the education area. If you say the digital commissioner should become the driver of educational change, you then appear to be like, are you saying the PTST or WebWise would be transferring to the digital commissioner out of the Department of Education, which I think the Department of Education would feel that was its natural home. But the work of the NCCA, the work of the, as they call it, the PTST, the Continuous Professional Development Agency within the Department of Education, that is a coordinated and effective structure of designing, delivering and executing education content to improve people's digital safety online. So I just wonder what, like, is it a research capacity you see the Digital Safety Commissioner saying, you know, maybe you haven't thought of that, or should you be? But I think coordinating when they don't have the power structure creates the danger that you have someone with apparent responsibility without the tools to execute, where the Cabinet Committee, the interdepartmental group driving to implement the changes, and the Advisory Committee has a structure that's, you know, has been thought out, and it's designed to get maximum impact in this area by driving cross-government activity, forcing departments to work across the silos and working to agreed goals set by government with report back to the Cabinet Committee. I think it's a structure that certainly I've seen it work in my own experience with, you know, where I was working in the employment area. Certainly that structure worked, and, you know, I wouldn't have been advocating then creating a czar for employment outside of those structures, because they wouldn't. I would be questioning their capacity. I think in the area of research, I'm not sure that there is joined up research being done across the system, and I think maybe that's an area where this strategy needs to think more clearly about research, but presumably that will evolve from the work of the Advisory Committee working into the structure that's been put in place in government. And again, you know, I think the committee ought to think seriously about, you know, taking a lot of these roles out of a structure that we've put up, and you know, it's there. I'm sure you've read it, but you know, there are, as far as I can remember, there are about 50 actions here. They're quarterly. You know, 19 of them are this year. There's about 60 next year. Sorry, for 25 this year. Yeah. So you know, we actually have, if you like, the horse is in motion, the train is moving, it's gone out of the station, and there's a good deal of work being delivered. So just to think about that dimension of the bill, I would certainly have some misgivings about whether it would add value to what's being done. And that's not to say we shouldn't be critiqued for what's being done, and I think the advisory group will be there to critique, as of course the Parliament itself, the Dáil and the Seanad will be there to critique. You know, I think that's really it. I mean, the department will, you know, there are some technical things there, I think, that will have to be worked through, and we will, as I say, be getting advice from the Attorney General, so that when officials come back, I'm only a week in the job myself, and I'm not pretending to be right across all of these, but my officials will come back if there's, you know, technical, legal issues that need to be teased out as you proceed. But that would be my initial reaction to thank the Deputy for the bill. I see the value in moving away from self-regulation, that we need to design a structure that is effective in this area, but we don't want to create something that you know, in these other areas that may not add to the effectiveness of an internet safety strategy that, you know, is well underway. And, you know, I'm not saying you know, when this was launched, we recognise this is a dynamic area, keeps changing. We need that advisory committee. We need to be looking, you know, horizon scanning to ensure that what we're doing is effective as the threats change.
Minister, I'm going to bring back in. Will I go around before I come back to you at the end? Yeah. And just before I bring in the members, thank you, Minister, for that. And just to let you know, I know the issue was raised in relation to other jurisdictions, and we as a committee are going to be going to Strasbourg, meeting with the European Commissioner for Digital Society and Economy, and I think that's a very important strand to this, that where you have online content that needs to be moderated, that if it originates in another jurisdiction, we could have the best law put in place here, but if it originates in a different country, it's very hard to deal with that. So we want to work at a pan-European level on that as well, and see if we can progress that area. And also just in relation to looking to best practice across the world, I know you made reference to Australia. The Australian Digital Safety Commissioner, I heard an interview with her, and her view is that she has the power to fine. So there's the stick and the carrot, but she never really needs to use the stick or to fine. It's through engagement with these social media platforms that encourages them to take down this content where it's abusive, where it's illegal. And I would assume that they could work, the Commissioner would work in tandem with the law enforcement agency within that particular jurisdiction. I think that's why we need to be working at a European level as well, from our point of view here. I'm going to bring in Deputy Dooley and then Deputy Stanley. Thank you.
Thanks very much, Chair. And just to thank Deputy O'Leary for the work that he has done, and I think he has given the recognition to the Law Reform Commission that he has worked with in bringing the bill to the level that it's at. We've supported you and will continue to support this initiative. I may have some amendments at a later stage, because I certainly think we need to strengthen the powers that a Digital Safety Commissioner would have. I take your point about the definitions, but I certainly think that it's important that fines would be set out in the legislation. I think they have to be very significant, because quite frankly I don't trust the social media platforms to adhere to anything unless there's a very significant monetary penalty there. I just recognise that the Minister is relatively new to this area, but he'd certainly have experience from his time in education and the concerns by the education sector generally about the harmful impact of the kind of online bullying that goes on, and the very significant impact that's having on children. So I would hope that, Minister, in furthering this effort, that you look to addressing the situation now rather than later, because there's little doubt that children, not just children but vulnerable adults as well, are definitely in danger and being harmed every day. So as time goes by, we don't want to leave it 5, 10, 15 years. We don't want to allow this to get out to a point where we're depending on somebody else to tell us what to do. And whilst I accept there's good work going on in other European jurisdictions, it's for us to try and implement, insofar as we can, rules and laws here that govern to the extent of protecting our own. I'm conscious that the Germans have made very significant advances in this area, and as a result of that, the digital platforms employ significantly more people there to ensure that harmful content is removed more quickly, and they do so because the law penalises them if they don't. So I think it's certainly worth looking at that. I don't think we can wait necessarily for Europe to force us or to wait that step. I think we can be groundbreakers and we can be leaders in that regard. Yes, for sure, the digital platforms have very significant basis here, and I don't want to make a charge against you or the government, but I'm taken to some extent, particularly by the Taoiseach and his infatuation with these digital media platforms and their mega wealthy owners. They're always up for a selfie with the Taoiseach when the opportunity arises. And whilst we must recognise they're really important employers here, I still think that it shouldn't be a Wild West for the digital media platforms, just because we value their significance in terms of the benefits to our economy. We must also ensure that we have a rule-based society and that these people are brought to book. I welcome the fact that you've said it's time to move beyond self-regulation, because we've had Facebook and others here before us, and they publish their own guidelines and protocols. And on the face of it, they look fantastic, and anybody would sign up to them. But yet, we saw that investigative programme done by Channel 4. You may or may not have had a chance to look at it, but when you see what they do at management level, and when you look at the way they moderate their own content, it's very clear that the content that I think the vast majority of the people who watched that programme believed was harmful, it was in breach of the guidelines, of their own guidelines, their own regulations, but yet their moderators were saying, yeah, no, this is okay, this is fine, a child being beaten, people talking about self-harming, and we saw people who, demonstrably were impacted and affected by that content being left there for very considerable periods of time. They were aware of it. It was in breach of their own stated protocols and guidelines, and it was being used as training material to say it's okay to leave that there. Now, We regularly hear, and I have great respect for the Facebook people and the way they've built their company, but this idea that, oh, this is not material we'd want up there, well, that somehow it impacts negatively on people who advertise. They don't want to advertise around this content. But sure, the model for Facebook, for all the digital media platforms, is to try and retain you in their space for as long as possible. And their stated intention that they'll only take down content where you're gratifying it or you're in some way engaging positively with negative or harmful content. But yet if you add a tag to some negative piece of content or a negative video, isn't this awful? They kind of seem to suggest that that's okay because free speech, then it's okay to leave that up there. But that's furthering their agenda, because if I comment negatively about some hurtful, harmful, damaging content, I progress, I promulgate that information and others view it. And that works for Facebook because, quite frankly, it holds me and my friends longer in their platform. So we've got to stand up to them. We've got to protect our own. We've got to protect our children and particularly our vulnerable adults, because whilst a lot of this debate talks about children, there are vulnerable communities out there. I mean, I think that programme, for me anyway, signalled the difficulty with people who have certain forms of mental illness, and how I was taken by one particular young adult who felt that, she had an affliction whereby on certain occasions she self-harmed, she cut herself and drew blood. And this idea that others that were talking in this open chat environment about doing that it was almost creating an impulse, an encouragement to go greater than the last person. Now that really is difficult and harmful content. And if that was going out in a broadcast environment, if we were listening to that on our radios or on a television channel, there would be uproar as from a societal perspective. But you can do it on your iPad, you can do it on your iPhone, you can do it on your smartphone, you can access all this information. So I just think as a society we haven't captured the extent to which this material is right there, personalised to everybody and accessible. And yet we put massive amount of regulation in what our national broadcaster can do, what our local radio stations can do, what our independent broadcast sector can do. We seek to put in place phenomenal controls, but yet this is far more accessible, far more direct, and we kind of have this laissez-faire approach because it hasn't really reached the level that we expect it to reach yet, because it's developing, it's evolving, and I don't think that's going to be an excuse long-term, Minister. I think we'll have to act. So I welcome the fact that you have signalled movement. I think you'll have to come a bit further as you read your way into the brief, and I think this bill forms the basis, but it can be built upon to offer those protections.
Thank you, Deputy. I'm going to bring in Deputy Stanley.
Thanks, Sherlock, and I want to welcome the Minister, your first attendance at the meeting of the committee, and wish you well, and Donncha O'Leary, Deputy, who has brought forward this bill. I think, the Minister heard him outline about the interdepartmental group, and while it has a role, I think with something like this, this has become really a big issue. And I mean, I was here through all the hearings with Facebook and other platforms, and the one thing that was clear was, and I welcome the fact that you accept that the days of self-regulation are over. But the other thing I think we need to look at, Minister, is, and Donncha as well, is that when everybody's in charge, nobody's in charge. And I do think that there's a role here for a very, very clearly defined role as set out in the bill. And the bill will need amendment. There's amendments I think that I'll be feeling to it as well, but I think it does set out the basis of something to work with. But it does set out clearly the functions of it, in terms of promoting digital safety, ensuring oversight, removal of harmful material, the powers of force and takedown, responsibility, collecting and analysing information, advising the government, and to work with the Ombudsman for Children and indeed the Department of Education as well. And I think that it's a very, very important area. I know my granddaughter started using the internet and I got worried about her. But now I think she's worried about me because she knows more about it than I do. If any problems with the phone or anything, I just hand them to her and she sorts them. She doesn't tell me how she sorts it, but she sorts it and hands it back to me. That's all I need to know. But there is a real issue here, and you know, the amount of time that's being spent on it and the amount of engagement with the various using the various platforms is serious in terms of walk down the street or any day here you can see it, and I think it's important that we move now to do this. Just in relation to so I do think that I hear what you're saying about the interdepartmental group, and that you use your term, you want to get people to working between the different silos in terms of getting that kind of cooperation. But I do think when everybody's in charge, nobody's in charge in any organisation, and particularly something as big as this at state level. Just in terms of the technologies as well, there's huge progress being made, and there will be, even by the time maybe this bill comes through here, there will actually be other forms of technology, there will be other advances being made, and we have to run to catch up with that as well. And we haven't. I mean, this has literally happened. It's crept up on us and it's here, and we're ill prepared for it. Just in terms of the jurisdiction issue, and I read the legal advice on it here. That we received here to the committee. The complicated jurisdiction provisions are set out in EU Regulation 40/2001, and while I accept that, I do think that the whole area around jurisdiction, I certainly would like to see some more work done on that part of it, and that we try and get greater clarity around that, about how you would actually work to enforce that. And I'm not suggesting for a moment that's a reason to do nothing. I think that it's just one of the challenges that we're faced with. The other area was in relation to penalties, and as I was reading the bill, the powers of the Commissioner and that in section 10. Not section 10, dealt with jurisdiction, just section 8 and 9. My apologies. And the question, just wrote a note here, in relation to, should the Commissioner be able to issue a fine, maybe in terms of, you'll have other agencies, for example, something as basic as under the Dogs Act, that the dog warden can issue a fine, but obviously more serious matter will come before a court. And in this case, the suggestion is here that it's the Circuit Court, and it may actually go higher than that obviously to a High Court if necessary. But I'm just wondering here, should we have a section in the bill, provision in the bill, for the Commissioner to be able to issue some kind of penalties there at that point? The other one was in relation to, just under the Code of Practice, and I know I'm working at the back of the bill and working back through it under section 4, the term harmful communications is mentioned in it, and I'm just wondering, should harmful and illegal be there in the same sentence, or maybe harmful replaced with illegal? I just think it's an area we need to look at. But look, I'm just highlighting those issues. There are just a few issues that I noticed when I reading the bill itself and the legal advice, and indeed the briefing note for today as well from Deputy O'Leary. I think it's needed. I think we need to do it. I don't think we should wait for the European Union. I think that we're moving to roll out the internet. Hopefully we can roll out broadband to allow people to more access to it, and it's one of the other roles of this committee, as you'll discover fairly quickly, Minister. So we're going to have more people engaging with it, and it's just very, very important that we do it. Just one area, and I don't know how, I haven't got it resolved in my head how we would deal with it. There's a particular, along with the usual abuse, or I suppose the common abuse that's on it, and bullying and that does need to be dealt with, and there may be some kind of more minor sanction for that Commissioner could issue, and I think that might be useful. And I mean, I think it's okay to say this, that we lost one member of this House who was subjected to serious bullying online, and some of us may have political differences with him, and indeed we have some people who are still with us, who are members of this House, who are subjected to huge intimidation and bullying on the internet. And we have to really, and that's just one area. I mean, it's not just public representatives who get it. People in all areas of life get it, and I think we need to try and move to protect people there. But one specific area that has emerged in the last couple of years is that vulnerable people are being targeted, elderly people, and they're being profiled by people living in this country. I believe people, widowers are one, elderly men who lose their wives maybe or something like that, or elderly women who lose their husbands, and to be targeted by criminal international gangs who are, who befriend them, so to speak, on the internet, and they build up a relationship with them, and they think that they're talking to, a girlfriend or a boyfriend or whatever in another country, and they're sending money to them. And I come across that one really serious case of that, where an elderly gentleman was borrowing money to send into a foreign bank account, thinking that he was sending it to a person. I advised him that, in my opinion, he was sending it to a criminal gang, and I actually got another person in the community, maybe somebody who might have more influence, to speak to the man about it. But I'm not too sure what you can do about that. But I suppose I'm making the point just to highlight that it's literally it's a wonderful tool. It's great, the internet. It has many purposes, but it's also a very, very dangerous world out there, and we've seen that. And there are many examples of it. And I don't know whether the last example that I gave, I'm not too sure. I'm not an expert on IT, but I'm not sure how that could be dealt with. But I think we should move ahead with this and use this as the basis for getting very, very strong, robust legislation in place and getting a Digital Safety Commissioner in place.
I want to bring back in Deputy O'Leary, if you want to respond.
There's a few things there. I suppose firstly, in relation to, just to clarify, I suppose, in relation to what I've outlined as, I suppose, a general basis for definition of harmful communications, not all those behaviours are that I enumerated, and I suppose they were general behaviours rather than specific offences. They're not necessarily, I think, all of them criminal offences. Some of them are proposed criminal offences from the Law Reform Commission paper.
I think that's been...
Yeah, but I suppose they're not currently criminal offences
right.
For the purpose of drafting this and so on. And to be honest, my view is that, you could consider whether this should reach the threshold that only communications which are at the threshold of being criminal could be subject to takedown procedures and the regulations in this that are proposed in this. I don't think that would be the right approach. I think there are behaviours which are extremely harmful, which probably fall short of criminal, and I think the definition would have to take that into account. I also believe that if we were to use the word criminal specifically in relation to a definition of harmful communications, and I'm open-minded on this, but it seems to me that there's a danger that you could be entering into the area of a commissioner being responsible for the administration of justice, which obviously can only happen before the courts and through the Gardaí and all that's constitutionally provided. So I think my initial view is that it would be better to stick with the phrase harmful communications, but to define that specifically, to take in areas that include issues which are criminal behaviour. And I would say as well, there's an awful lot of things that go on online in terms of abuse and all the rest of it that would currently qualify as harassment, that would currently qualify as a variety of criminal offences, as stalking, for example, but very often they're not progressed to the Gardaí and to the DPP and so on. But I think there has to be a category just short of that should be subject to takedown procedures as well. There's a balance to be struck there because you need to be conscious of freedom of speech, but I don't think we should only be dealing with things that are in fact criminal. And I think it's a fair point that's made in relation to the platforms. It would very likely be the case that I think in some circumstances that where they see certain behaviours that they would refer this to the Gardaí, but that would depend upon the nature, I suppose, of the communication or the behaviour. And as I say, I don't think that every harmful communication that we should be looking at should be at that level, because I think that's a very high threshold, and an awful lot of the things that we want to address would perhaps would fall short of that. The Minister spoke in terms of what added value. I think, look, I suppose I'll quote again just in relation to Facebook themselves, that we see great benefit in a single office having the ability to oversee and coordinate efforts to promote digital safety. I think if you're in the space that you're talking about self-regulation is no regulation and we're going beyond that, then you need something that is a regulator, and this is essentially what we're talking about here. And if you have a regulator or a commissioner of this kind, it has to have real powers. And if it has those real powers and it is involved in taking down material that's harmful, intervening with platforms, perhaps occasionally having to go to the court to see things enforced, but you're dealing with that kind of responsibility all the time, then it makes sense. This commission will be the body that will be at the front line of developments in social media and behaviour on social media. And the people who are on this body and who are working for this body, they will be the first to see the dangers that exist with new platforms or new uses of platforms. So I think absolutely, it is right and proper that they would be responsible for coordination. Having said that, that's not to say that every person who's dealing with online safety in any government department or body at this moment in time needs to be subsumed into it. I don't think that's the case. But I think that they need to be the central body for coordination and designing policy and identifying issues that are arising in different platforms and their use. Of course, it's the case that there should still be people in the Department of Education, in whatever form the Department of Education may see fit, who would be responsible for addressing this and identifying how the stuff is worked out through the schools. But they should be talking to a Digital Safety Commissioner saying, look, what's been happening recently and what are the new platforms and so on. And that's the dialogue that I think needs to happen and so on. The Ombudsman for Children, I think, can have a role in communication, but the direction and the formulation of research and analysis of what's harmful and what the best way of dealing with it is should come from the Digital Safety Commissioner. In relation to Deputy Dooley's point in relation to strengthening powers and in relation to fines and penalties of that kind, I'm very open-minded in that regard. I think it is a power that does exist in the Australian E-Safety Commissioner and in NetSafe in New Zealand. I think that is something that's well worth considering. I'd be interested in the Minister's views on that. But if you have a Commissioner, it's important not only that they have powers to remove things, but that if they're not getting cooperation from those platforms, that they can sanction them, not only through the revocation of the certificate of compliance, which is, I think, an incentive to an extent, because the certificate allows parents and users to identify what's safe and what's not. But I think there is a case for going beyond that in terms of sanctions such as fines and so on. The point's been made in terms of Europe, and I recognise that there's a lot being considered here, but there's nothing that I'm aware of in European legislation that precludes us from doing this. And if we're talking about formulations of proposals that Europe is currently considering, European legislation can take 8 or 9 years. I don't think there's any sense in us waiting. We have, I believe, there is a consensus in this country that this is something that needs to be proceeded with. We need serious regulation. Self-regulation needs to be brought to a close. So I don't think that we can afford to simply stand around and wait for Europe to take action and see what they come up with, because we could be waiting a very, very long time. The point in relation to jurisdiction raised by Deputy Stanley, as I've stated at the start, what's proposed, and it is proposed first of all by the Law Reform Commission, is not particularly radical in terms of extraterritorial effect. It's limited to situations where harmful communication affects an Irish citizen or a person ordinarily resident in the state, and the means of communication used in connection with that harmful communications is in the control of an undertaking or company established under the law of the state, or such harmful communications affect an Irish person or a person ordinarily resident in the state, or where the means of communication used in connection with such harmful communications are within the control to any extent of an undertaking established under the law of another state, or where a court established in this state would have jurisdiction to give notice of service outside the state in respect of civil proceedings to which harmful communications refer. So that's in keeping with Orders 11D of the Rules of Superior Court, 1986, and I think many other areas of the rules of the courts. This is standard enough, so far as I understand it, and certainly there's no great difficulty in bringing cases. There may be, I suppose it's fair to say, in practice, in pursuing people on foot of proceedings brought before the court, but I don't think that there's any difficulty in what I've outlined here, in the ability of the Commissioner to actually bring proceedings. I think that that's absolutely possible. Just to sum up there in terms of it, just 2 or 3 final points. Look, I think, as I've outlined, there is, I believe, a consensus. Self-regulation is no regulation. That's the case across a wide range of sectors. It should be the case here. It's an issue that affects an ever-growing percentage of the population. I think we need to be ambitious, and I think we need to be imaginative. Other common law jurisdictions, such as Australia and New Zealand, have put in place very robust regulators and commissioners with real teeth. There's no reason, with another common law jurisdiction such as ours, that we can't do the same. So I think we need to do that. And I would like to take the opportunity, because I don't know that he stated it clearly, to ask the Minister if he favours, generally speaking, whatever about the technicalities and the detail, if he favours putting in place a commissioner or an office of a regulator of the kind that's outlined here, generally speaking.
Thank you, Deputy. Thank you. And just in relation to working at, I suppose, European level and nationally here, I think it would be remiss of this committee. I know you not to look at working and pushing the agenda at a European level, and certainly we need to be looking at what we do here. We could lead in that space. That would be my own view, but we cannot ignore working at a pan-European level. And I think, knowing how long things take in politics generally, I think we need to start now and not to ignore our European neighbours in relation to pushing something like this forward.
Maybe, well, both of you, what do you think the timescale for moving this legislation is? We obviously have some more work to do.
I think the Minister might be able to better answer that, but I don't see any reason in terms of legislation. I think we do this pre-legislative scrutiny. We need to consider the details that arise out of it. I think we should be looking at coming to committee stage in the spring. That's my view, and progressing beyond that. There is a bit of taking stock of what comes up in these hearings, but I would believe, I don't see there's any reason why not.
We have meetings scheduled over the next few months, and our next one is on the 6th of November with other social media platforms and the ISPCC and the Department and Cyber Safe Ireland. So we'll have to see how we go, and obviously try and work as effectively and as robustly as possible in relation to this. Minister, did you want to come in there?
Just very briefly, just to answer directly, clearly there is a regulatory task to be done if we're moving from self-regulation to something that is overseen. So someone needs to oversee that, and I think that has been clear from everything I said. I think the Deputy, correctly in my view, is anticipating this going beyond criminal offences, because criminal offences, there is, if you like, a liability already there, and they have a responsibility to take down, and they will be exposed if they failed. So this is moving into a realm beyond the criminal, but where we believe it's in the public interest, and I think Deputy Dooley articulated that in some of the examples he quoted. But I think the corollary of that is that if you are talking, as Deputy Dooley is, of fines, you can't have what is a criminal, something for which people will be fined, undefined, even not set out as to what the potential offence that they would be fined for. So I think, the more you go down a penalty route in this, the more important you define what harmful communications represent and what is the category on which you're creating this obligation. So I think that's important to bear in mind. I know Facebook may like the idea of one digital safety commissioner, but to be honest, would we be going to Facebook to know what's the best way of providing resilience to students in our schools, or would we be going to the NCCA, who has membership from the trade unions, from curricular experts, from all sorts of people who create who have experience to implement policy, or would we be cutting out Webwise, or saying Webwise, who is, to my mind, on the cutting edge of what they're doing, waiting for someone else to tell them what to do. And I think Deputy Brian Stanley asked the question, it is important to have someone accountable. Well, in the structure we have now, it's from the Taoiseach down through the ministers who are accountable. There's an action plan we have to deliver. We will be held to account in each department for the delivery, each department with their responsibility, and their date line is set out there. So it's not that no one is being held accountable. So I think
I'll just let the Minister finish.
Yeah, I think you just need to be careful not to, in the desire to to say the Oireachtas is serious about online safety, therefore we set up some central body. That's not always the way. Yes, it's important for the regulatory task. We have to have someone who regulates and delivers and does that. But it's not necessarily true that we need to put a stamp on the door of someone and say, if you want digital safety, that's where you go to, because really we do need all these people to be working effectively together, delivering a suite of programmes and working across the silos, as I said. So I think that's an area that I think you do need to give a bit more thought to what it is this role is. Like, perhaps at the time this was drafted, the Ombudsman for Children was seen as the cutting edge of where information about this was. I think now it will be seen that, Webwise, NCCA, others, NCCA, like under this, has to integrate it right across their curricula. They have to be conscious they're being asked to develop, both in primary curricula, secondary curricula. There's a well-being curriculum in place, which has very much at its heart helping people to be resilient in dealing with social media and the threats that come their way. So, there's a lot of work that is integrated to what's already done. So just be cautious of just saying we need to hang a sign on someone's door and say that that now have solved the problem. It's not going. The solving the problem is down under the bonnet in this day in day out work.
Just to clarify, or just to
clarify
briefly what I meant, Minister, and I don't wish to take away for 1 minute from the fact that that cross-departmental work is happening, right, or to anyway, reduce that or demean it. What I see that as having a role, but I think, in fairness, and I don't want to take away from the Taoiseach's question, the Taoiseach's ability to hold people to account in terms of the inter-departmental responsibility and intra-departmental responsibility. But I think, realistically, given everything else that we'll say that head of government has to look after, the more detailed and the more the minutiae of all of this, realistically, that's not going to be dealt with at that level. And I think, just to clarify, I think, and I know where you're coming from. I think it's the nub of this discussion. I think that the interdepartmental work and what the different departments recommend, particularly the Department of Education, the Department of Children, Youth Affairs, all of that is very, very important. And I think that I would envisage that feeding into the work of the Digital Safety Commissioner and of that link being made. But I think that it's not to demean and this happening, but to be unrealistic to expect any Taoiseach, whoever the Taoiseach of the day may be, to try and draw that together and make sure it happens, and to keep it moving.
Yeah.
I think getting anything done, you need the authority, you need the budget,
yes,
and you need the will to do it. What the Taoiseach would do is enforce the will of departments to do it, but the other two elements, the money and the powers, and they're set out in NCCA, they're set out in the budgets that are allocated, be it to education or justice or whatever. To get things done, you need the tools of power to deliver. Just calling someone a digital safety commissioner, he can certainly do the regulation, he or she can do the regulatory thing, but can they? They don't have the power, they don't have the budget, they don't have the legislative underpinning to do a lot of the things that need to be done. That's the consideration I'd ask the committee to look at.
Do you want to come in finally, Deputy?
Yeah, look, I mean, just on this specific point, look, I mean, I think it's been a very good discussion. I think there's been a fair few issues outlined, and I hope, I'm looking forward to the next session as well, which I think will be very, very interesting. But just to address the Minister's point, like, it seems to me, just to boil it down, that the Minister is saying, yes, we need self-regulation. There's no regulation, fair enough, then we need regulation, but it should just be regulation, and it shouldn't be involved in the advisory or policy side of things, which doesn't seem to me to be...
No, advisory would be fine, but not
policy.
Coordination. Execution and coordination, I think, is for somewhere else. But certainly some.
But I don't think it's necessarily envisioned that execution. Like, I mean, execution obviously is for the people who have those powers of statute. But coordination and development of policy, I think, is something. Like, I mean, look, I mean, that stuff can be considered further. But I do think, as I say, these are the people who are going to see the changes. First of all, who are engaging with the social media platforms. And none of that is to say that there aren't people who will be other government bodies and departments that wouldn't have responsibility. And again, it would be about cooperation and communication between them. But I do think there needs to be, if you're going to have that regulator, it needs to have the ability to feed in to all those other bodies and those other people's responsibilities, what's happening, what changes are developing, and how best to respond to them.
Thank you very much, and I want to thank Deputy O'Leary for coming here today with your bill, and the Minister and Ms Quill and Mr O'Brien. It's been a very worthwhile engagement, and we look forward to interacting with you over the next few weeks and months ahead on this. Thank you very much. So the Joint Committee is adjourned until 11 a.m. on Tuesday the 6th of November. And all the opening statements will be published on our website. Is that agreed? Agreed. Thank you.